Hello, welcome back to the 10,000 Startups podcast. My name is Roger Royce. I am your host of this podcast. I'm also a partner with Haynes and Boone in Palo Alto. I do emerging growth and venture capital. And today I just want to give you a quick update. Our Attorney General here in California, where I practice, last week issued two advisories on the use and development of artificial intelligence, AI. And the advisories affect basically the application of existing California law to AI, and secondly, the application of existing California law to AI in healthcare. Now, as you know from this podcast, we recently did on artificial intelligence. We had a whole host of new laws go into effect as of January 1 of this year, 2025. Those laws included the new disclosure requirements for businesses using AI, laws around the unauthorized use of likeness, a person's likeness, the use of AI in election and campaign materials, and some prohibitions on reporting of certain exploitive uses of AI. The advisory now expands a little bit on that, but also goes a little further and talks about the application of existing California law to some of these new AI technologies. I think it's important, first of all, just to define terms so we know what we're talking about. And the advisories define AI, it's sort of a fuzzy thing to define, but the way the advisory defines it is as a quote, machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments. So super broad. It's a super broad definition. Uh, and there's a specific California law for one specific purpose that defines the term in some instances as, quote, an engineered or machine-based system that varies in its level of autonomy and that can, for explicit or implicit objectives, infer from the input it receives how to generate outputs that can influence physical or virtual environments. Okay, so those are broad definitions generally, but I think this is one of those things that we know it when we see it. I think you will find it's not going to matter a whole lot since the laws I'm about to talk about, they apply whether it's AI or not. They apply just generally. Now, let me just kind of jump into, before I do, the advisories kind of point out some of the concerns that apparently the Attorney General claims to have about this. Um, for example, the fact that the tools are being deployed so rapidly that we have situations where AI is generating false information or biased and discriminatory results, which is represented as being neutral and free from human bias. So that's one of the concerns. And the advisories just point out that developers in particular can be held accountable under short contract or other laws if their AI results in harm, especially if those AI systems are employed negligently. Now, we had talked about this in our recent podcast. Are we going to start seeing developers get sued for negligence if the AI causes some harm? And you may recall there was some very specific legislation that was introduced last year that did not pass, that would have really raised the bar and would have imposed something a lot like strict liability on developers of AI for any harms that it caused. That law did not pass, but we still have existing law. So let's get into that. So number one, California has an unfair competition law that seems to pop up everywhere in litigation. I'm not a litigator, but I'm certainly aware of this law because you see it come up. And the law is designed to generally protect the state's residents against unlawful, unfair, or fraudulent business acts or practices. It's Business and Professions Code 17200. Now, like I say, it's a very broad law, and it just comes up in a lot of litigation in places where you might not expect it. And one of the reasons why is because under our unfair competition law, it's a violation of any other state, federal, or local law becomes independently actionable. Now, what does that mean? Independently actionable? It means you can get sued. So if you violate a state law, let's say there's a state minimum wage law or something, and you violate it, well, you've not only broken a law, there is now an independent action that a plaintiff, some California person who's been harmed by it, can recover for. They can sue you for the damages they suffered as a result of your breaking the law. So the scope is super broad, and it incorporates a lot of other laws. Um, Here's a handful of other laws related to AI that might apply, according to the notice. The first and most obvious one is just false advertising, right? So if your AI or if you, the developer, falsely advertise the accuracy, quality, or utility of an AI system, that could create a cause of action. What could that mean? It could mean claiming an AI system has a capability it does not, claiming that a system is completely powered by AI when there's humans responsible for performing some of its functions, which, by the way, I know has happened. Representing that humans are, or claiming that the system is accurate when it's not, claiming that it performs better than a human would when it doesn't. It's such like claiming that an output meets industry or other standards, or, and this is interesting, this is right in the notice, or claiming that it is free from bias, if it's not, presumably. Okay. Second case, using AI to advance deception. And the notice specifically talks about deep fakes, chatbots, and voice clones that appear to represent people or events or utterances that did not exist or are otherwise deceptive. Or even to fail to disclose that AI has created a piece of media. I would have to assume we'll have to read into that in a case where it's not obvious that it's AI. Using AI to create and use it and knowingly use somebody else's name, voice, signature, photograph, etc. Using AI to impersonate a person for purpose of harm, intimidation, threat, or defrauding that person, for purposes of receiving money or property, which is a crime. So those are just a few of examples, but you get the idea. Using AI to impersonate a person, using AI in a manner, this is a good one, that is unfair. Or using AI in a manner that results in negative impacts that outweighs its utility, or in a manner that offends public policy, is immoral, unethical, oppressive, unscrupulous, or causes substantial injury. So these are super broad, fuzzy standards, which litigators will love, of course, and the AI people actually probably deploying the AI are not going to love so much. Secondly, we have a false advertising law in California, which is another set of protections or gotchas, depending on how you look at it. Our false advertising law, again, very broadly prohibits false or misleading advertising. It's unlawful for any person or business to distribute any statement to induce the public to enter in a transaction which is untrue or misleading, and which is known or which by exercise of reasonable care should be known to be untrue or misleading. Okay, so what does that have to do with us? Well, if your AI, or rather, if you are using false advertising regarding capabilities, availability, utility of AI, then you could have an independent cause of action here. Okay, and then the second part of this is, what if the AI generates something that's false? That again, could violate our California false advertising law. We have competition laws in California which prohibit anti-competitive acts, such as below-cost sales, loss leaders, etc., that sort of thing. And our competition law, as discussed above, covers a lot of this. So just keep in mind, you might also violate the California competition law, which gets brought in to a private right of action under our unfair trade practice laws. California civil rights laws. We have a civil rights law in California. It guarantees the freedom and equality of all people within the state. So again, same thing. AI could cause a company to end up violating those laws. And in particular, what we're worried about here is when an AI system incorporates a bias into its decision making, some sort of societal or other type of bias. So the developers and the users have to be wary of this, the fact that you might end up violating this law. There are a handful of election prevention misinformation laws election misinformation prevention laws. They don't really apply to the startups, so I'll skip them here. The next set of things that the notice warns about is the application to our data protection laws. So, as you know, the AI is only as good as the data that it's based on. Well, here in California, we have a lot of rights around data. Interestingly, California has a state constitutional right to privacy that it guarantees its residents. It applies both to government and private entities. In other words, it's not just public entities that could breach this right. Any private company could breach an individual's constitutional right to privacy. And specifically, informational privacy is a core interest protected under our California Constitution. So developers and entities that use AI really have to be careful about this and carefully monitor that. The California Consumer Privacy Act, CCPA, which we've talked a lot about in my podcast, specifically applies to data, California consumer data. And it, again, very broadly regulates collection, use, sale, and sharing of personal information. And there's a heightened protection for sensitive personal information. And that could even include, this is important, it could even include inferences about consumers made by AI systems. So think about that for a minute. That's going to be covered by our CCPA, according to the notice. Okay, so what are some of those rights that our CCPA grants California consumers? Well, number one, the right to know what personal information the business is collecting about the consumer, how it's used, and how it's shared. The right to correct inaccurate personal information that a business has about them, the right to be forgotten and delete personal information collected about them, the right to opt out of the sale and sharing of their personal information, and the right to limit the use and disclosure of their what we call sensitive personal information. I won't get any further into the CCPA. We've got other podcasts about that. For purposes of today, I just want to let you know how AI applies to this. So in particular, we also have the California Invasion of Privacy Act, which impacts AI training data, inputs or outputs. It restricts recording or listening to private electronic communication. That's wiretapping. These are old laws that were designed. I guess it's old wine, but poured into a new bottle, you might say. It's designed for different scenarios, but the notice believes that it applies in this case. The wiretapping law, CIPA. Wiretapping, eavesdropping, recording communications without the consent of all the parties, or recordings or intercepting cellular communications without the consent of all parties. Since AI that does that sort of thing is going to be violating this law potentially. We have heightened protection for certain types of consumer data, healthcare data, which I'll talk about in a minute, education data, and AI developers are going to have to be aware of that. And finally, we have a confidentiality of medical information law that governs the use and disclosure of a Californian's medical information that anybody who develops AI systems is going to have to become available with. Now, before I get into the second notice, which talks about the use of AI in healthcare, I just want to summarize the new California laws that are going into effect on January 1. So, as I said, disclosure requirements. We have a new law that requires AI developers to disclose information on their websites about the training data on or before January 1, 2026. We have another law that requires telemarketing calls that use AI-generated marketing to disclose that. We have another law that requires AI developers to develop tools to detect whether specified content was generated by generative AI systems, and to offer visible markings on our content so it gets identified as such. We had a couple of bills that prohibit the unauthorized use of a likeness in the entertainment industry and related context. And we had a couple of bills that put restrictions on the use of artificial intelligence in election and campaign materials. And then finally, there were some prohibitions against we'll call it the exploitive uses of AI. That would be things like child pornography, non-consensual pornography, deepfakes, etc. The first notice concludes with a warning that there are other tort, nuisance, environmental, business regulation, and criminal law that's going to apply equally to AI systems and to conduct that would be illegal, whether they involve AI or not. And it kind of points out that conduct that's illegal is going to be illegal, if AI is involved. In other words, it's not going to be a defense to illegal conduct that the AI was involved. You may recall on our podcast, we discussed a case not arising in a state or in this country, but an interesting issue had to do with a chat bot that was giving incorrect information, and the defense was that the owner of the chatbot raised was, "Hey, don't look at me. I didn't give you that bad information. It was the chatbot. Go sue it." And that didn't get very far, and it's not going to get very far in California either. Okay, secondly, artificial intelligence in the healthcare sector. This is apparently important enough to call out separately and have a whole separate advisory about. Now, coincidentally, just yesterday, I'm talking to you on January 22nd, just yesterday, President Trump announced the Stargate AI deal, $500 billion going into AI, part of which is going to, a very substantial amount, which is going to go into developing AI in healthcare. And if you saw the press conference, you probably heard some of the biggest players in the industry, some of the biggest companies in the business, talking about developing an AI system that has very, very ambitious goals. Curing cancer, for example, early detection of cancer. They reference specifically the mRNA vaccine and using AI and liquid biopsies to find biomarkers in blood. Okay, so very timely, if given what's happening in the market. So the advisory points out that AI systems are already in widespread use in healthcare, and it's only going to get to be more and more. And it's not only for appointment scheduling and risk assessment and sending me bills. It's also for things like diagnosis, treatment, testing, etc. So the advisory points out that there's the potential that AI has to really help in healthcare to improve patient and population health. And given that that physician error accounts for probably 250 to 400,000 deaths a year in the United States, I think the system could probably use a little help. At the same time, however, the advisory points out that AI risks causing discrimination, denials of needed care, and other misallocation of resources and interference with patient autonomy and privacy. In particular, once again, it talks about training on data that reflects existing biases, and that might exacerbate health inequality. That's probably a problem in drug development generally, is who your patient data is. Just as an aside, we know that uh, clinical trial results don't always match real world results just because the patient data that they test is different. So we'll see if AI can get beyond those challenges. But in the meantime, as a legal matter, what we're worried about in California when using AI in healthcare is that it might be unlawful. Here's a couple of examples. If the AI results in a denial of health insurance claims in a manner that overrides the doctor's views about necessary treatment. Uh, it may be unlawful in California to use generative AI to draft patient notes, communications, medical orders that include erroneous or misleading information. Uh, a third example, to determine patient access to healthcare using an automated decision-making system that makes a prediction based on past healthcare claims data, resulting in some disadvantaged groups that have a history of lack of access to healthcare being denied service. And then there are a few other examples where basically if the AI makes a mistake is what I think is what we're saying generally. You've probably heard that there were some recent changes in California law that limit a healthcare service plan's ability to use AI to deny coverage to somebody. So, in other words, a plan can't use these kinds of tools to deny, delay, or modify healthcare services based in whole or in part on medical necessity. Instead, a healthcare service plan has to ensure that the AI does not supplant a licensed healthcare provider's decision making. It bases its decisions on the enrollee's medical history, doesn't discriminate, it's open to inspection and audit, is periodically reviewed for maximum accuracy and reliability, does not use patient data beyond its intended purpose, and does not cause any harm to the plan enrollee. So California definitely has some specific plans that relate to insurance and healthcare service plans. California also has anti-discrimination laws that prohibit discrimination by anybody receiving any state support, including an entity that's engaged in the business of providing health care. So again, same thing, these laws might be implicated by discriminatory applications of AI. And there are several state laws prohibiting discrimination, but at a high level, I think you get the idea. And then finally, California has patient privacy and autonomy laws that may be implicated here. And actually, California's state medical privacy laws are more restrictive than the federal health privacy laws like HIPAA, which everybody seems to be primarily concerned with. For example, our Confidentiality of Medical Information Act and our Information Practices Act, which govern the disclosure of California's medical information, requires covered entities to preserve the confidentiality of patients' medical information and ensure that they have access to that information. For example, physicians are required to provide information that a reasonable person in the patient's position would need for informed consent. That's right in the law. It's in the regs, rather. And there were, as I mentioned earlier, there's been some recent amendments that require providers and electronic health records and digital health companies to keep certain information confidential and separate from other medical records. And some medical information is more confidential than others. Let me put it that way. And there have to be protections in place to prohibit the disclosure, access, transfer, or processing. And it also imposes additional requirements on healthcare providers and insurers and others regarding getting a patient's informed consent before disclosing medical information. So, and by the way, this extends to genetic data and other types of medical data. And I know I said finally, but let me say finally again, the second notice does also warn the provider and the developers and the users of AI that there are a lot of other California laws that might apply, and the fact that you're using AI is not going to be a defense if somehow you make a mistake. So that's it. Those are the two notices from the Attorney General's office on AI coming coincidentally right about the time of the Stargate announcement. So stay tuned. I feel like we're going to probably see this stuff get developed in the case law as we go forward. But for now, at least we know we have a framework for some of the rules that we should comply with. This is Roger Royce, 10,000 Startups. See you next time.